Hi, Andrew Pfeiffer here, back from Pfeiffer Law again here in Akron, Ohio. As part of my practice, we do a lot of probate and trust administrations, and the middle phase of a full administration in Ohio, this is a phase where we will account for assets and we will value assets. We have to account for what is in the estate, and sometimes we have to appraise assets. It's important to note that there will be decisions made in this portion of the probate estate that can affect tax basis and can affect taxes that are going to be paid by beneficiaries or heirs. So as always, we're trying to minimize administrative costs and taxes. This is a portion of the estate where we will sometimes have real property appraised. Sometimes a business appraisal will be done if there's a business in the estate. Sometimes we have to appraise unique property, art, gun collections. I mean, you name it, just different unique things that we need to understand. What is the value of these things so that we can then go to our distributive phase of the account? This is the middle portion of a full administration. So for context, the average length of a full administration, in my experience here in Summit County, Ohio, between 10 months and a year. So this would often be 3 to 4 months after doing initial filings, getting an executor appointed. Sometimes we have to pick an appraiser. But this is the phase of the probate process in which we are really figuring out what are the assets of the decedent? What are the assets of the estate? This is the portion of a full administration where we are notifying the court what the assets of the estate are, working with the fiduciary appointed by the court, the executor or the administrator, to get appropriate assets inventoried and appraised if necessary. And lastly, it's important to note that at each of the 3 phases of the process, the interested parties of the estate have an opportunity to be heard by the court. So this comes out of due process from the United States Constitution. But if somebody wants to contest what's on the inventory and say there's not assets listed that should be listed, or things are listed that really are not valued correctly, or if there's any sort of pushback from an interested party about what is on an inventory that's going to be filed with the court in an estate, there's an opportunity to get a hearing and get in front of a magistrate or a judge and present evidence. Beneficiaries can retain independent counsel from the executor, who would often be represented by the estate counsel. And so, you have an estate planning or probate attorney that's representing the fiduciary, but other beneficiaries are free to get their own attorneys as well, and to take a look at what has been filed with the court. Is it being valued fairly? And are we ready to move to the last phase of the estate? Ohio is what's called a notice-driven probate state, which means that each phase, if you're an interested party, you should be getting notice of who's involved, what's involved, and how monies or assets are being disposed of. And you should get an opportunity to object, and you should get an opportunity to be heard and to say, well, wait a second, let's take another look at this. And so thank you so much for tuning in today as we continue to talk through the inventory and appraisal phase in our larger series on Ohio full administration probate. Thank you.